It's going to be all right. All right. Let me admit her. Let me do this and this. And I'm going to start the slideshow. So I appreciate you guys coming, spending 45 minutes to 60 minutes with me. This is the Ann Arbor Real Estate Investors Club. Today's Fundamental Friday class is on contracts. I'm going to cover addendums and releases, but the primary focus is going to be on the purchase agreement today. I'm going to cover other contracts and agreements in subsequent sessions, but I can't cover it all in a relatively short period of time. I do encourage you to grab a pen and a pad of paper, take notes. I always find, and they always say that that's the best way to learn. I will have a cheat sheet at the back end because, again, I'm have a lot of material to cover. I'm going to go relatively quickly, but kind of hopefully not too quickly that it's overwhelming to the point of annoying. But contracts is not the most glamorous subject, but I appreciate you guys for taking the time to give me your time, and you should congratulate yourselves for taking the time to learn about this because there are so many people that jump into real estate, and when the time comes to sign contracts, there's quite often deadlines involved, so you really don't have time to thoroughly read and digest what you're signing and what you're getting yourselves into. So my advocacy is to be proactive and learn about this so you've seen these documents before there's a figurative gun to your head to sign these things. So I appreciate it. We've got a couple new folks on the call today. I know, just by way of quick introduction, the Ann Arbor Real Estate Investors Club, I formed it 16 years ago. And over the years, my focus and my purpose in the group is focused on learning, networking, and deal making. So today we're doing learning and some networking. Yesterday we had our Rainmaker session. We did a lot of networking, met some new folks, and had a great session. And deal making, because quite often we have a large group. Deals and opportunities happen between members of the group. That's the focus of the group. I do these Fundamental Fridays classes because I believe are a series of fundamental topics that you need to familiarize yourself with and practice on an ongoing basis. And I use this slide, as a way of helping you learn, but helping you build confidence as you learn that if you focus on the fundamentals, the level of everything you do will rise. And if you get yourself familiar with the fundamentals, and if you work and practice on them, you know, it's a tremendous help, because real estate investing, there's a lot of shiny objects out there, we call them, that can take you off into different directions. And I encourage you to focus on the fundamentals. So when I say fundamentals, this is a list of fundamentals that I have created based on my 21 years in the business, um, as an investor, as a realtor, working with lots of investors, working with lots of buyers and sellers over the years, not only in investment properties. So I developed a series of classes that are like 10,000 foot overviews of each of these topics. But these are topics that you should familiarize yourself with what they are, and then really familiarize yourself with learning more about each of them however you want to do it, whether it's through my classes or YouTube classes or books or, websites or whatever. These are the topics that you will come back to on a regular basis, if not a daily basis, as you go out throughout your real estate investing career. So I do them kind of in a sequence. I make them as self-contained as I possibly can. There is some, logical sequence to some of them. Um, but we are in contracts today. The upcoming sessions over subsequent weeks, over the next couple months, will be due diligence, power team, compensation agreements, which isn't on this list, multifamily, and foreclosures, just so you kind of get a real lay of the whole land. All right, I'm going to jump in today. Today's session is informational only. Okay. I am a realtor. I am not an attorney. I did go 2 years to law school many, many moons ago, but that's another story for another day. But I'm not an attorney. So it's not intended as legal advice. Um, I am always advised to tell my clients and prospective clients to engage the services of an attorney, because, I often use the expression that, buying real estate is not like buying a pair of shoes. It's a they are complicated transactions. Every one has a little bit of a different wrinkle. They're not all cookie cutter. And you really need to have an attorney on your power team. I'll talk about a couple alternatives and referrals to attorneys and an attorney service. Um, but this is my disclaimer that you really need to, put on your list if you're going to be doing this, to have an attorney in your stable on your power team. All right. So I want to make that clear. Because again, another little caveat is you will engage with realtors, you will engage with other people in the business as you go on. They say, oh, you don't need a lawyer for this. Oh, just sign this. Oh, this is standard. Oh, you don't need to worry about it, blah, blah, blah. And if you don't know any better, you don't know any better. But it's up to you, to say, wait a second, time out. I'm not comfortable with this. I'm not comfortable moving forward with this unless and until I have it vetted through an attorney. All right. So that said, let's go. Today's objectives, as I said at the top, I'm going to cover the purchase agreement today, a typical buy and sell agreement, and disclosures which go along with them. And I'm going to say this at least a few times, that disclosures that go along with a purchase agreement are themselves contracts. Um, and I will explain the differences as we get through them. I'm going to talk about addendums. And addendums are additions to the contract. All right. Um, and those are legal and binding, and they're made a part of a contract. And then I'm going to talk a little bit about releases, mutual releases or disputed releases. When you get into a contract, but something goes haywire and you want to get out of the contract, and how do you extricate yourself from that? All right, so I'm going to cover those really kind of fleetingly. Um, so contracts, all right, for all transactions, and I know I've got a couple people on the call who are not from the state of Michigan, so I'm going to put another disclaimer on here that the contracts I talk about are mostly required in the state of Michigan. I don't know what requirements are in other states because I don't practice in other states. So I don't know what they are. So I'm talking about Michigan here, but if you're not in Michigan and doing business in other states, I encourage you to find out quickly, what paperwork and what contracts are required for a purchase agreement, um, and make sure that you follow the law and follow what's supposed to be done. And don't assume, because this is the paperwork that Michigan requires, that it's going to be the same in another state. If you're just starting out, you don't know what you don't know, and you figure, well, real estate deal is a real estate deal and it's all the same. It's not true. All right. For every transaction, you need a written purchase agreement, because for every transaction, the transaction is going to be processed through a title company. Okay. And the title company requires a written buy and sell agreement. And they, in the state of Michigan, and I have heard this, I don't know that it's a fact, but all of the transactions I've done in 21 years and all of the title companies I've dealt with in 21 years require an additional document, which is known as a seller's disclosure, and another document that is called a lead-based paint disclosure. All right. I don't have examples of those today. I can get you those if you really want them, but I don't have examples of those today. But I'm going to cover what they cover, and why they're important and why you have to have them. So you need those three documents. The title company is going to require those three documents at a minimum. Okay. Now, then as you get into being a real estate investor, you're going to do transactions that involve a realtor in the transaction, typically on both sides. A seller will have a realtor and a buyer will have a realtor. That's 85% of the transactions. All right. But as an investor, there may be occasions where a transaction is done without a realtor involved, which is direct buyer and seller, okay, which I don't recommend you do, but investors do, or transactions that involve a wholesaler and not a realtor, in which case, when there's that person in the transaction, there's what's called an assignment agreement. All right. That's a contract, typically between the buyer and the wholesaler. But the title company will need that assignment agreement unless the transaction is done outside the view of the title company. But I just want you to get familiar with what these documents are. And like I say, I can't go into all of them in 45 minutes, but these are the most important ones that you've got to put on your radar screen today. And purchase agreement, seller's disclosure, lead-based paint disclosure, transactions with a realtor. I'm going to talk about this in not the next session, but the following session, about agency disclosure agreements and agency agreements. All right, I'm going to do a whole session on that, because the rules have changed a little bit. There was a court case and all this business that took effect last August, and there's a lot of changes in how compensation agreements are explained, and who pays who is basically the bottom line of it. But I'm doing a whole session on that in a couple of weeks. And then the assignment agreement, which I just talked about. All right. So addendums. So you have a basic contract. I'm going to do a little bit of a walkthrough of a basic contract that I hope won't put you to sleep. I'll try and keep you woken up on that. But once the basic agreement is entered into, then what starts is a period of we call it due diligence, which is going to be I'm going to go in detail on that in the next session, which is not next Friday, but the following Friday. But these are typically written documents that start flowing back and forth during the due diligence period. And the due diligence period is the time between the original contract has been signed and the time that the deal is supposed to close, because there's a closing date on the original agreement. So during that time period, that's known as due diligence, and that's when, we sharpen the pencil, we get into more detail, questions arise that didn't we didn't know about when we signed the original agreement, and the like. So addendums come into play as an addendum, which is Latin for an additional terms that are part of the original agreement. So typically addendums involve, we need to change the date of the closing, or we need more time to do this, whether it's the financing or inspections or whatever. So we need to change the date on the original document to a new date. All right. That's an addendum. You negotiate a change in price. That's an addendum. Addendum says, in reference to this deal signed February 7th, the price of the property is now X, so that negates what the original agreement was, and the addendum supersedes it. An escalation clause is typically not in a purchase agreement, but it's in an offer. Okay. It's in an offer where you're going to offer a price on a property, um, but there are multiple offers. Okay. So you want to get the deal. So there's quite often, it depends, not all sellers will accept an escalation clause. But what an escalation addendum is, when you're writing an offer, you say, all right, I am willing to pay $100,000 for this property, plus I am willing to pay $5,000 more than any other offer you might receive, up to $125,000. All right. So you're offering $100,000, but if there are multiple offers and people are offering more money, you're willing to offer more than those offers, up to a particular ceiling. All right. That's an escalation clause. I could do a whole class on escalation clauses, but that's what an escalation clause is in essence. All right. Um, Contingent on closing. This again is for an addendum to an offer, which means that it typically is not in investment properties. This is more common for personal residences, purchase agreements. But it's saying, I am willing to offer $100,000 on 1234 Main Street. However, I can only offer that if I sell my property at 123 Elm Street. Okay. And then a seller has to agree or not agree or whatever, on that. Again, it's typically involved with residences, rather than investment properties, because it may be I mean, it's anything can be in any offer or addendum, um, but it's not typical in an investment offer. But I want you to know what it is. Um, Personal property. So personal property is typically, um, attached as a separate from the purchase agreement of the real property, because the transaction that the title company handles is focused on, a piece of brick and mortar that has a legal description on it. So things like, appliances, or snow blowers, lawn mowers, things like that. Personal property is the subject of an addendum, which is separate from the purchase agreement. Just so you know that. We get into things like, you know, things that are, is something mounted on the wall or not mounted on the wall? If it's mounted on the wall, it's considered part of the property. Those are all the legalities that people like to get up in arms about. I again, just be aware of them. Short sales were very popular when the market crashed. Um, they're not as popular now, but you need to be aware of them in case it crops up and what they are. And a short sale is typically on the seller side. So the seller, because it's been a seller's market for so many years that they're not around that much anymore, but they do happen. And again, you should be aware of them. A short sale is when a enters into a sales agreement with a buyer, but the purchase price is less than what the seller owes on his or her mortgage. Okay, so follow along with me for a minute. So let's say, 123 Main Street, let's say that the seller owes $125,000 on his mortgage. But you've entered into a contract to purchase it for $100,000. Okay. So now here's where the short sale comes in, is that it's incumbent upon the seller cannot sell it for $100,000 unless his mortgagor agrees to that sale. So that's part of the mortgage agreement. Okay, so what the mortgage holder can do is say, yes, I agree to the sale. I'll sign off on it and we'll work out the details. That doesn't happen very often. What more likely happens is that the seller is still on the hook for the difference between the sales price and what he or she owes to his mortgager. But that's between the mortgager and the seller, but it has an impact on the transaction even though the bank is not a party to the transaction. So this is where the water gets muddy. This is where deals get delayed. Like I say, these days it's very rare, but you should be aware of it. That's why I put it on the slide. Leases, okay, this is common in real estate investor transactions. Okay, if you're a real estate investor as a buyer or a seller, and there's a tenant in the property, okay, and there's a written lease with that tenant, okay, the buyer has to honor whatever is in the written lease. The buyer doesn't have to honor anything that's not written. Okay, if it's not in writing, it doesn't exist. Okay, so you as a buyer of an investment property have to honor a lease that's in place. Okay, you can't just say, well, I'm the new buyer, so I'm the new landlord, I'm the new sheriff. The lease doesn't, no, the lease supersedes the purchase agreement, and the lease goes along with the purchase agreement, and you're obligated to honor it. So I use an example. One of my associates has got a property on the market right now where the seller has a lease in place for another 2 years until 2026 or 2027, where the rental amount is way below what the market is. Okay. And obviously the tenant is not interested in moving, because the tenant is getting a great deal and the tenant has a great lease. But the fallout of it is nobody wants to buy that property and inherit that lease. Okay, so you need to be aware of it. And as a seller, if you're selling a property that has a tenant in it, you are going to want to be sensitive to what a potential buyer is going to want. So in my oversimplified example, a buyer is not going to want to inherit a long-term below market lease. So you want to make the leases you have in place coincide with the sale of the property. That's the scenario that makes it most attractive to a buyer, because then the buyer can get the tenant out, fix it up, raise the rent. That's what buyer wants to do. Okay. Um, Key exchanges, things like that, contingency removals and extensions. Again, typically in an offer, I've got a situation now, which happens very common. An inspector comes in, inspects, you have the purchase agreement, you have 7 days to do a home inspection. Inspector comes in, inspects the home, goes in the attic, says, I think there's mold up here. You better get a mold guy in here to do a mold test. Okay. So, all right. So buyer says, all right, well, we want to do a mold test, but we need more time. We can't do it because it's already 6 days to have this inspection. So you have to have a paper trail for all of this work, and addendums, contingency removals, and extensions of time. All of that stuff has got to be documented. It can't just be verbal. It can't be via text or voicemail or handshakes. It's got to be in writing, because when these things blow up and go south and you get the attorneys involved, first thing the attorney's going to do is say, give me the file, give me your paper trail, give me what's in writing, and don't talk to me about anything that's not, oh, well, I've got a text here that says this. Well, no, that's not going to fly. So you have to be meticulous about this stuff. And it's hard, and it's a pain in the butt. But it has to be done. It just has to be done. And it's very frustrating, but you have to not let yourself get frustrated, and you have to keep telling yourself, have your little, you know, person on your shoulder, keep talking in your ear, Brian, what happens if this thing blows up and goes south, and you're standing in front of a judge somewhere sometime? What are you going to tell him or her? Are you going to pull out your phone and say, well, I have my text here? Well, that's just, they're going to laugh you out of the courtroom. Okay. So that stuff is not going to fly. And no matter what anybody tells you, you know, plan for, plan for the best, hope for the best, but plan for the worst. And keep being meticulous about keeping a paper trail is should be part of what you do, should be part of what your realtors do. And I know it's part of what your attorney will tell you to do. All right, that's addendums. Real quickly, releases. Okay, I'm going to talk about earnest money. That's EMD, earnest money deposit. That's what the acronym for earnest money. Um, that's typically, the biggest question when things go south and one of the parties wants out, or both of the parties want out for whatever reasons. The dispute is usually around the earnest money. And disputes come into play when stuff is not in writing. And again, I'll say, in writing doesn't mean an email. It doesn't mean a text. Yeah, you can use them if that is all you have and you're in a big blow up and it's a lot of money and you want to fight for it. But those type of situations are where the attorneys meters are going to be running, because you didn't keep your ducks in a row. You didn't have it in writing. You have to prove, did this person receive the text or not, or what? You don't want to go there. Is all I want to tell you about that. Um, Attorneys or Legal Shield. I'm going to introduce you to this. They are attorneys. It's called Legal Shield. I happen to be, full disclosure, a representative of Legal Shield. I encourage you to go to legalshield.com and check out what it's about. I'm not selling it today. I just want to make you aware of it today. I can talk to you more about it if you have, say, hey, Brian, can you tell me more about it? I'm more than happy to talk about it. I'm not going to do that today, but I'm going to encourage you to put this on your list and check it out because a lot of investors use Legal Shield instead of an a la carte attorney where you have to pay a several $1,000 retainer every time you pick up the phone. So I don't have time to go into this anymore today, but I want you to be aware of it and put it on your radar. Um, Upcoming events. All right, I'm wrapping it up here because I'm going to dive into an actual contract. Um, I'm not doing a session next Friday because I have another commitment. We had a Rainmaker session yesterday, so our next one is in 2 weeks. 2 weeks from today is a session on due diligence where I do a deeper dive into these addendums and contingencies and how to utilize them to your advantage. Um, Compensation agreements is the following week because they're going to be a part of 8 out of 10 transactions at least. And then Jesus, we're into March already. So there we are. All right. Um, Again, this is for those of you who are new. I encourage you to, think of this group the way you think of, like LA Fitness or gym or a church. You get out of it what you put into it, but you only get out of it if you go. um, for those of you who are new, the book I recommend, it's called The Millionaire Real Estate Investor by Gary Keller. I consider that book this group's Bible. Um, and I encourage you to create a business plan. If you're going to create a career, or if real estate investing is going to be your primary source of income, I encourage you to set goals and write a plan and then execute the plan. I beat the drum about that all the time. Um, I'll talk about membership fees at another time, but I'm going to get out of here and go to, oh, no. Can you guys see this contract or do I have to do a different share? Hang on.
Yep.
Oh, you could see it.
This says go to contract.
Oh, you don't see an actual contract.
No.
Okay. All right. All right. My technical skills here are, I can do it, but I can't do it on the fly here. Or there. Now can you see it?
Yes, now we can see it.
Okay. So here's something that I want you to be aware of because again, when I started out, I didn't know. I figured, oh, a sales contract is a sales contract and they're all the same. Well, that is not true. Um, Again, I know, Raj, I know you're not in Michigan. So I encourage you to get familiar, again, here's the disclaimer is get familiar with the contracts that are used in the state that you're doing business, that you're doing the transaction. That's an obvious one. But here's the kind of the second level is this is a real estate one contract. I work for Real Estate One. That's my brokerage. Every brokerage has got their own version of a sales contract. Now, yes, the major elements are the same, but not every provision and every paragraph is the same contract to contract. They all usually have price, terms, closing dates, contingencies. They all have the main elements in one form or another, but there are other nuances that are different to each contract. And in the state of Michigan, there are Real Estate One has a contract, Century 21 has a contract, Keller Williams has a contract, Remax has a contract, different realtor associations. There are a dozen or more of them within the state. They have a version of a sales contract. Okay. So this is where it gets overwhelming, especially when you're brand new, that you're taking the time today to that learn that there are differences, because otherwise you wouldn't know. You'd never know, because you're going to interact with the people who you interact with, and they're going to show you what they use, but they're not necessarily going to tell you that there are other versions out there. But I'm going to do that. But anyway, this is a real estate one contract, and it's in the process of being changed because of that compensation new rules that I was telling you about. But this contract that we use, okay, it's 6 pages long, 45. You can see there's 45 paragraphs, 45 different paragraphs. And I was going to use the example. I mean, this stuff will bore you to tears, but you don't want to gloss over it because it bores you to tears, because it's important. I was going to use the example. My wife needs new tires on her car. All right, I'm going off in the weeds here, and she went and got a quote and a contract for tires. And there's a contract to buy new tires, and the contract is like in 4-point font, but it's a contract that they want her to sign, and nobody explains anything. They just say, hey, you want tires? Here, sign this. And, give us, they want $1,000 for tires, which is ridiculous. But anyway, I make this point because, once again, if you don't study this beforehand, you're going to go out and you're going to look at a property with a realtor, without, you're going to say, yeah, I want this property. I want to write an offer. I want to write a contract. Somebody's going to shove some paperwork in front of you and say, hey, Diane, yeah, you want this deal. There's 6 other people that are writing offers too. You better sign this real quickly. And you're overwhelmed because, number one, you don't know what you're signing. Number two, you're not sure you trust the person who's shoving this in front of you, and you don't really know what you're getting yourself into. And again, buying a piece of real estate is not like buying a set of tires or buying a pair of shoes. So you're learning this. This is prime time right now in these next few minutes. Seller's broker, buyer's broker, seller and buyer acknowledge receipt of the state of Michigan disclosure regarding agency relationships. All right. You don't know what the hell that means. I'm going to tell you in 2 weeks, but I can't go into it today because we don't have enough time. But this is what you're going to, so you're going to look at number one and say, well, wait a second. I haven't seen this disclosure document, so I can't acknowledge that I haven't received it. I haven't seen it. So I can't get past paragraph number one. And again, I kind of make light of it a little bit, but you can't make light of it. But I will explain it to you, but it's going to be a little bit down the road. For the property known as 123 Main Street, this offer is dated February 7th, 2025, between seller, which is public record, and buyer, which is you, or if you are a real estate investor and you have an LLC or a corporation and you're purchasing in the name of the corporation, that's where that name goes. Okay. Conveyance, all right, that this property is in the city of Ann Arbor, the county of Washtenaw, and here's the legal description. And you have to spell that out, because the title companies, when they're providing title insurance, creating the deed and the legal document that says you're going to own the property, the document's not going to say 123 Main Street. It might say that, but the title companies go by what the legal description is, which are in the tax records. And they're typically a long string of code words, section 126 north of this perimeter and all that, based on a geocode and all that fun stuff. But That's what the title companies go by, and that's what the deed goes by. That's what your ownership goes by. Okay, so that's especially appropriate if you're buying a property. The seller happens to own two properties next door to each other. One has a house on it, one's a vacant lot. They have two different legal descriptions. Okay, they have two different legal description numbers. You have one legal description in here. You're not getting that second piece of property unless that's on here. And you say, well, wait a second, that's what I thought I was paying for. The owner told me, that I'm getting both lots. Well, guess what? Lot number two is not on the contract. It's not on the deed. You're not getting lot number two. All right. That's part of the due diligence I'm talking about. But that's why you got to be acutely aware of legal description versus property address. This is also real critical in vacant land, but it's critical in every transaction. All right, sales price. All right, this is where your offer is. Earnest money deposit. Okay, earnest money. It's written into every contract, but it is really customary. It is not a legal requirement. You will hear lots of people tell you, oh, you have to have earnest money, even if it's $1. Well, that's not true. They can tell you anything, and anybody can say anything, but it's not a legal requirement. What it is a demonstration of good faith. Um, And again, it's a negotiating point, which I kind of talked a little bit about last week in negotiation. That if you're willing to put earnest money down, it means you're serious about buying the property. And it means that you're not going to, you're not playing around and you're not going to back out unless there's a real solid reason. Okay. That's basically what it is. Typically, if I'm representing, this is what I do. If I'm representing a seller, I want a buyer to put down a lot of earnest money. Okay. If I'm representing a buyer, I want to put down as little as possible. Okay. Again, it all has to do with looking down the road. If the deal goes south, how are you going to get out of it? And how badly are you going to be hurt if this dispute about the earnest money can't get resolved quickly in one way or another? That's the essence of it. Funds and terms. Are you getting a mortgage? Are you purchasing under a land contract? Are you purchasing in cash? So you have the price, the earnest money, the terms, okay, which I talked to you about last week, are the main elements of the negotiation. Seller concessions, again, these are more common in residential purchases than investment purchases, but you need to be aware of them because they can come into play. Where if you're financing a deal, you want a certain amount of credit at the sale, so you have to come out with less money out of pocket as far as transaction costs are concerned. I can't go into that. I'm not going to go into that more. Um, this is, we talk of the buyer brokerage fee and who pays what. I'm going to talk about that in 2 weeks. Other. So here's where you put in an escalation clause. This is part of the offer. Here's where you put in the escalation clause is, buyer is willing to pay 1,000, 2,000, 5,000, 10,000 above any other offer up to, X number of dollars. You strategize that with your agent. You have to initial each page. Inclusions, all right? This is stuff like carpeting, shelving, garage door openers, screens, awnings, um, and the following personal property. This is where you write in appliances, and make sure you know this. If you're buying a property and you go in and you go into it's typically you go into the kitchen, there's a refrigerator, stove, washer, dryer. Okay, great. You write the offer, you buy the property, you go to your final walkthrough, all that. Hey, where's the refrigerator? Where's the washer and dryer? Well, that wasn't part of the contract, so it's gone. Well, wait a second. It was here when I wanted to buy it. If it's not in writing, it doesn't exist. If those things are not written into the agreement, you consider that you can't consider it part of the agreement. Property condition. We get into disclosures, which I'm running out of time. Home warranty. This is when it's a buyer's market. If it's a buyer, if we've been in a seller's market the last at least 3 or 4 years. But if it's a buyer's market and there aren't multiple other offers, if you're a buyer, you might say, all right, well, I want to write an offer on this property, but I want the seller to purchase a warranty on the washer and dryer and the refrigerator and the dishwasher for a year for me. Okay, that's part of the negotiation. All this other stuff is just kind of general legalese that you should make yourself aware of. Metered water and sewer. Okay, so utilities, most utilities attach to the owner or attach to the tenant. Water is the only utility, again in Michigan, I don't know other states, where the water bill, that bill attaches to the property, not the owner, not the buyer, not the seller. The seller is responsible for it, but it attaches to the property. And if you're a buyer, you want to make sure that the seller has paid his or her water bill. And typically that's done, the date of closing or the day before closing. You call up the utility department, the water department of wherever the property is, and you say, hey, this property is changing hands. I'm the buyer or I'm the seller. I want to get a final read. Okay. And they will get the final read. But when you close, you're going to hold a certain amount of money in escrow in case the seller doesn't pay that bill. Okay. If the seller doesn't pay that bill, use the title company will use that escrow money to pay off the water bill. All right. Tax prorations. Again, this is another part of the closing costs, and it depends on where the county or the taxing body of the location of the property. We get into this when we get into closing documents, but what you need to know is that the taxes just like the water, the taxes get prorated to the date of closing. So the taxes are divided out annually, whatever it is, $9,000 a year. They divide it by 360, which is what they use for a year, and that's the daily tax proration. And then the title company will calculate the taxes, whether it's, $22.60 a day, okay, up to the date of closing. And the seller pays the taxes up to the day, and then the day of closing going forward, the buyer pays the taxes. So now what happens is sometimes the seller hasn't paid the taxes, so that's got to be brought current as to the date of closing. Or sometimes the seller has paid ahead and the buyer has to reimburse the seller back to the date of closing. Hopefully that's not too confusing. It's kind of confusing, but just know that the taxes get prorated. As the buyer or the seller, you're responsible for the property taxes for when you own the property by the day. Okay. Um, Possession at closing. I'm just going to put the caveat here is, you know, I say never. Never let a seller have possession of the property after the closing. Period. I'll talk about why in a different session. Um, Title insurance. Title insurance has got to be part of every transaction. When you are a seller, the seller has to provide title insurance to the buyer. Title insurance is a policy which states that I, the seller, own the property, own all the legal rights to it, therefore have the right to sell it. Nobody's got a lien on it, nobody has a claim on it, etc. Okay, I, the seller, have to buy an insurance policy that guarantees that. So someone can't come down the road and show a document and say, wait a second, I own this property or I own part of it, you know, it's mine, it's not your. Well, you say, well, wait, I just bought it. Well, no, that's what the title insurance is for. So the seller has to buy title insurance for the buyer. Buyer has to buy an owner's policy for the lender. If you are borrowing money from a bank or a lender, you have to provide an additional policy to that lender in case something goes south. The insurance company pays off the lender. Okay, that's in every transaction. Um, that's 29. Notices, offers, counter offers, notices required by contract be delivered in person by mail, email, and other electronics, and where with verifiable signatures. Electronic signatures are binding. So I talk about all these addendums and the contracts and the paperwork, and they're all done by electronic signature, not what we call wet signatures anymore. But this is again is why notices. This doesn't say, you know, texts are legal documents, voicemails are legally binding. It doesn't say any of that because that's not true. All right. It's only stuff that's in writing with electronically verified signatures that have been signed off by all the parties. Here we talk about the financing. Here we talk about the disclosures, which I have run out of time to dig into. But here are the contingencies, and the typical contingencies are property inspection. So this is standard. Um, this is standard in every contract. I'm writing a contract for 1234 Main Street, $100,000 earnest money, but I want 7 days to inspect the property. So that's a contingency. So my offer is contingent on me getting an inspector in there. It's the typical inspection time is 7 days. All right. Because sellers don't want to take it off the market for longer than they have to if you, the buyer, doesn't like it or doesn't pass your inspection. All right. But this offer is contingent on an inspector coming in, doing his thing, and me saying, okay, yeah, after the inspection, now I know all the gory details of what's wrong with the property, and I still want to go ahead. Typically, this is the point where a contract might get renegotiated. Happens all the time. Sellers may or may not know of the condition of the property, but once an inspector goes up in the attic and says, oh, you got bats here, or oh, you've got mold here, seller hasn't been up there, doesn't know. Buyer now says, well, time out, we got rodents, we got we got mold, we got to talk, we got to see how bad this is, um, what it's going to cost me to fix, um, and am I willing to eat it, or am I going to ask the seller to pay for it, or are we going to split it, or whatever? That's typically where the negotiation, where offers get renegotiated, is after the inspection. And I just did a whole class on that last week. Municipal inspections. All right, this is um, uh, this kind of does come into play with investment properties. Is that if it's a property that has a, if you're buying a property that has a tenant in it, that property should have a current certificate of occupancy, which means that the municipality has inspected it and signed off on it and says that it's safe for a tenant to live in there. Now, in reality, that doesn't always happen. So, and especially during COVID, but that's all long past now. But now you can say, as a buyer, you can say, well, show me the certificate of occupancy, which is typically part of the offer, that you want to see that before you write the offer. And the seller will say, well, I got one, but it expired 2 years ago. Well, here's where you, as the buyer, say, well, okay, I'm okay with that. Or you say, well, look, I'll write the offer, but you got to get it inspected. You got to get a C of O before I will sign off on this offer. So as an investor, you want a current C of O. If it doesn't have one, perhaps you can negotiate a much better deal, but that's part of the negotiation. But anyway, you want one and you're entitled to have one, and the property should have one if there's a tenant in there. If there's not a tenant in there, um, it doesn't have to have one, but if you're going to use it, you're going to have to get one way or another. So you're going to want to get the seller to get it if possible. All right, we're on 34. I got to get to 45 here real quick. Well and septic. Again, these are for rural properties that that don't have public sewer and public water. Attorney approvals. This is where my disclaimer from slide one kicks in, where yeah, I'm going to sign this offer as a buyer with my realtor, but I'm going to sign this, but I want my attorney to sign off on it before it goes into effect. So here's the attorney approval contingency, is that, yeah, I'll enter into this, but my attorney's got to sign off on it, within 5 days or whatever. That's what this is for. Um, Sale of the buyer's property, that's what I was talking about earlier, that I will buy this property, 123 Main Street, if if I can sell my other property. Um, that's this provision. Um, when we're in a seller's market, most sellers won't agree to that as part of the offer, um, but some will. Again, the market may be changing a little bit. Um, we'll see. But here's what's called a limited time clause and a backup contract. So a limited time clause. So let's just assume that the uh, the seller agrees to this sale of property provision. Okay, and so you've entered into a contract on 123 Main Street. You put your property on the market, but it's not selling. You're not getting activity. You don't have any offers. Nothing's happening. In the meantime, someone else becomes interested in 123 Main Street. Okay, seller says, well, I'm into a contract, but it's contingent on the sale of another property. But if you write me another offer, I can engage this limited time clause. And so what the limited time clause is means, all right, I want to buy 123 Main Street. I've got the contract with the sale contingent on my property. And Raj comes in and writes an offer on 123 Main Street. So then the seller comes back to me and says, Brian, I've got another offer. I want to engage the limited time clause, which means I will still sell it to you, but I'm not going to wait for you to sell your property anymore. You got to buy it now or get out and let me sell it to Raj. Okay. So you, me, or whoever I lost, forgot who's the buyer, still has right of first refusal and still has control of that property, but you've got to now waive that sale of your property in order to buy this other property. Okay. Hopefully that makes sense to you. Backup contract, the same thing. All right. I enter into a contract. We're going through due diligence. We're going through the inspections. We're renegotiating this and that. Raj comes in and he says, well, I'd like this property. I know you're in the process of negotiating. I'm going to write a written backup offer, which means, if your deal with Brian blows up, I'm willing to step right in and take it. And that's a backup contract. Okay. Binding contract and assignment. This contract binds buyer, seller, their heirs, and personal representatives. This does not mean it's a wholesale deal. I won't get into that, but that's what the binding contract is. But here's what happens in the case of default. Seller represent they are not a foreign person, that they'll abide by all the tax laws, etc. And now you go back and forth with, the buyer signs it, seller signs it. Typically, there's some changes, whether it's dates or amount of earnest money or inspection periods and things like that. And then the last person to touch the contract signs final acceptance. This is 45. This is what's mean by the contract is bottom line. And that's it here. And with that, and that's the bottom line. And I apologize. I've gone 20 minutes late into the station. And I don't know how to chunk this out and to make it 40 minutes and cover it. So I am going to stop right here.